Hi, everyone. Good afternoon. Thank you for being a part of the Elder Justice Conference and coming to the third and final day. You all have been troopers. We hope it's been a great conference and that you've enjoyed all of the sessions. Today's session that we have is on the topic of Baker Act and behavioral health. And this is going to be somewhat of a panel discussion between General Magistrate Alvan Balent, who is the 11th General Magistrate for the 11th Judicial Circuit, and Karen Fagan, who's a staff attorney at the Legal Aid Society of Palm Beach County. Originally, we did have a state attorney component to this panel, Ms. Lourdes Roberts, who is a assistant state attorney at the Office of the State Attorney Katherine Fernandez Rundle in the 11th Judicial Circuit. She did have a family emergency and she can't be with us here today. So we're sorry we are going to miss out on her, but hope that all is well with her loved ones. So before we get into the content of today's presentation, I want to remind everybody that this is being recorded, that you will receive a copy of the recording at a later date, probably sometime next week. Additionally, as you all know, there is another session going on simultaneously. I believe that's on income and for tax regarding seniors. But don't worry, that's also being recorded. And even if you don't attend that, you will get that recording. So sit tight, enjoy the session that you're here with us for today.
This is the cooler session anyway.
Without a doubt. So additionally, if you need captions, just a reminder, we do have a live captioner present on the virtual platform. You'll just scroll down and click show captions. If anyone has any issues with that, please let me know. And finally, I actually didn't clear this with my presenters, so I apologize. Questions and answers, wait till the end, and if we have time.
Generally, if you want to, if you just put them in the chat box, we'll get to them at the end, and that way, because sometimes a lot of the questions will be answered as we go through our talk.
All right, fantastic. So I will do my best to monitor that chat function, and that way we can aggregate those questions at the end. Perfect. So I'm beaming ear to ear because I'm so excited for this presentation and these speakers. So without further ado, Magistrate Balent and Karen Fagan, the floor is yours.
Okay, I'll start. Good morning or afternoon or whatever time of day it is. Good something to everybody. I'm Magistrate Alvan Balent. As I said, I'm at the 11th Judicial Circuit and I handle Baker Acts for Miami. All right, and Karen and again, Lourdes does send her regrets for not being here. The three of us are going to be talking about the Baker Act and focusing a lot on the elderly, special considerations for the elderly population, as that's the area you work with. And how before though we get into those nuanced issues, and I'm going to try to share my screen and start my my PowerPoint. I need Alex, can you enable host participant screen sharing, please?
You should have that now.
All right, let's try this again. Okay. All right, now start the slideshow. Come on. From the beginning and display settings, right, which is the one that I take away there.
So you want to, yes, there you go.
Okay, so just as I said, now before we get into the sort of the more nuanced areas, we thought it would be prudent to talk to you all about as kind of what exactly is the Baker Act, because I'm sure everybody's heard of it, especially, and not to, with current events, any single time there's a shooting, there's usually, especially in Florida, there's some elements of mental history. The press always says the person was Baker Acted, but unless you are like Karen and Lourdes and myself, you don't really know what that means. So we're going to get into the basics of that. So when we're talking about areas, hopefully you understand when we mean, what an assessment or treatment petition, etc. And one of the first things we did, even though we're here about the Baker Act, that's just one of a series of laws in Florida for the special needs populations. You have laws with developmental disabilities. The Baker Act is for involuntary mental health treatment. The Marchman Act for drug addiction, adult protective services with DCF. I'm sure many people know what guardianship is, and then there's criminal laws as well. And now I have one other surprise for all of you. Congratulations. Even though you didn't apply or run for election, you all now have been appointed judges. Yes, Governor DeSantis, your letters are in the mail. But your chief judge has told me in respective circuits that you're all in the probate division. And guess what? You have Baker Act cases on your docket that you need to adjudicate right now. Yes, right now. Don't sweat it. It's only 3 cases. I have 28 on my docket for tomorrow. I had 46 on Monday. You'll be able to get through 3. So you're going to get a series of fact patterns. A poll question will come up, and then you need to tell us, Karen and I, whether you will commit or deny. So here's the first fact pattern. And Karen, at any time, if you wish, you can do the Jeopardy theme song to put a little additional pressure. Can we get the first poll question, please? So based on this fact pattern, come on, the poll question. Will you A, yes, commit, or deny? The person's not taking their medication, they're delusional, responding to internal stimuli, they're only eating canned food, and they slapped a nurse when they were going to seclusion.
Do, 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 do. You don't want me singing.
It's better you sing than me, because when I sing in the shower, the water wants to run back up the pipe. So
there you go.
You're the champion of the singing. So do we have the get your votes in?
Let me know when you want me to end it.
You can end it at any time.
All right, here we
We
go.
need the people to vote quickly. So what were the results?
There you go.
We had 72% no, 28% yes. So Karen, you're before you retired, you are winning so far.
Thank you, audience. I appreciate the win.
Lourdes is not happy, even though she's not here. Going on to the second question, somebody's next poll question. And boom. Okay, so we have somebody who's bipolar. They're unkempt and had illogical thoughts. They're not taking their medication, and they're aggressive and threatening behavior while on the unit.
Do, 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 do. We're done.
But no, it's now time for Final Jeopardy. You know? So get your votes in. Come on.
There we go. And I'll share the result.
All right. Now we have 71% said yes. And 29% no. That's almost a reverse of the other one. So apparently you guys don't like Karen winning. Good for you. Now let's close that poll and go to the third one and the final one of your cases. I know it's your first day as a judge. You're almost done. And there we go. We have somebody who is when LA is Los Angeles, just so everyone has become infatuated with an LA reporter who eventually takes a job in Miami. This person follows that reporter and they're going back and forth to and from Miami, starts believing they're married, had a child together, but the reporter has no idea who this person even is. And the person starts sending flowers, and signed as her husband. There's voicemails. As you can see, that tone of those voicemails changed when security stopped this man from seeing his alleged wife. And he started saying things that the wife's body belongs to the husband, vice versa, and he has a cage and a collar ready. Would you commit this individual based on that fact pattern?
I see folks voting still, so I'm going to leave it open. Still
any attorney there who's still voting, now you can never fault a judge for taking time on a case because you're taking so long to vote. No pressure. No pressure.
Do, 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 do.
Still coming in. All right, I'm going to call it.
All right. And we have 68% says yes, 32% says no. All right. Well, first order of business, congratulations on making it through your first day as a judge. Now, that's the good news. The bad news is that all your decisions have been appealed to the Florida Supreme Court. I've heard they're going to take the cases on an expedited basis, so we should hopefully know soon how you guys did. But in the meantime, let's now actually start learning about the Baker Act. Would have been nice to do that before, but hey, sorry. Now, in one other prelude to getting to the Baker Act itself, even though we're talking about, again, the elderly, is mental illness impacts everybody. It does not matter if you are gay, straight, white, black, male, female, rich, poor. This mental illness does not discriminate. Karen, Lourdes, and I, we see every population come through. There are different needs for different populations, but everybody comes through. So, and now I'm about to get to the Baker Act. I promise I'm getting there. Promise. There's a method to the madness. But before we get into the details of the Baker Act, we need to talk a little bit about the history of the law. So you know because you can't know where we're going till we know where we came from. The Baker Act came into effect in 1971. It was formerly known as the Florida Mental Health Act. Florida was one of the first states to come out with these laws, and it's named the Baker Act after Maxine Baker, a state representative from Miami. She was the sponsor of this legislation and shepherded through the process. The Baker Act, though, has now become synonymous sort of with these areas of law, even though many other states each state has their own, they call it different things, but especially in the Southeast, the term Baker Act is what a reference when somebody gets civilly committed. This bill overhauled over almost 100-year-old laws in Florida. And those laws, when I say there was really no criteria, no judicial review, you had no rights, you had none. You basically, if a petition came in signed by 3 people and they convinced the judge that you're crazy, into the hospital you go, and for however long you're there. And the new law tried to balance the individual liberty interests that are being curtailed with the state's interest to protect the public under their police powers and their patron patriae powers to care for those who can't care for anybody else's. If anybody actually wants a good book on a pre-Baker Act Florida, I would recommend Gilbert King's Under a Ruthless Sun. That book is a sequel to his Devil in the Grove book, and in this book, came out of Lake County. Against Sheriff Willis McCall. There was an actual rape this time, not like the Devil in the Grove prequel. White Citrus Baron's wife was raped by a black man. She told the police that Sheriff Willis McCall rounds up various people. And Willis McCall, by the way, he's so racist, he actually had 3 U.S. Supreme Court cases against him at the same time. That takes talent. And this was a case, even though they round up a bunch of black men, all of a sudden, Willis McCall places the crime on a man named Jesse Daniels, a 19-year-old teenager who now would be diagnosed with developmental disabilities. He was thrown into a hospital, and the book is about one reporter's dogless efforts to get him out. It's a fascinating book. I encourage you to see how much the system has changed. Okay, now, what is actually the Baker Act? The Baker Act, it replaced it with, you have a sort of a 2-tier process. Baker Act likes number 2, as you'll see. There's a voluntary process, which is encouraged. And unless you're a minor coming in for treatment, we don't see the case. With minors, though, until July 1st, there has to be a court hearing so that I can verify the voluntariness of the assent to their treatments. Minors can't legally consent. That is, the legislature did away with that effective July 1. Now it's going to be an in-house clinical review that'll be developed. What that means exactly will be defined by the Department of Children and Families, which oversees the Baker Act, but which is kind of a good thing because it is traumatic to take somebody to court, but that is changing. The involuntary process is potentially where Karen, Lourdes, and I become good friends. There's, again, a 2-part process, surprise, surprise, either inpatient or outpatient. And this talk is going to be focused more on inpatient treatment. The outpatient process exists. It's been in the statute since 2004. It, however, is rarely used because it's poorly drafted. For instance, it has 9 statutory factors. And any attorney in this room or has a legal education should know by heart that any test that's more than 4 factors, it is ipso facto incoherent. And the other more important part is after you go through all that work, you are basically handing people a bunch of toilet paper because you don't have continuing jurisdiction to enforce your orders. It's quite frustrating because the outpatient process is significantly less intrusive on an individual's rights. It's much less expensive than hospitalization. And the big flaw with the Baker Act is we're great at stabilizing people in the immediate crisis, but there is no continuum of discharge post-continuum of care. Outpatient would be a way to plug that gap, because if you keep people on their medications, we have less likelihood of relapse. So getting into either way of inpatient or outpatient, though, there is, again, a two-part process. You have an examination and a treatment petition, the treatment petition, which is formerly known as a placement petition. Now let's get into the examination process. And you guessed it, how many ways are there to start this assessment process? You guessed it, it's 3. Fooled you. Yes, it's 3. The police can take you in. That's the most common way. The medical professionals can execute a certificate, or you can come to court and file a petition, and the judge can review that ex parte. And as long as there's a reasonable basis that you meet criteria, you'll be taken to the hospital. What is the criteria? Well, it's right there on screen. You have a mental illness, and because of that illness, you're unlikely or just unable to tell that you need treatment or participate in it voluntarily. There's no appropriate, less restrictive alternatives other than hospitalization. And then the meat and potatoes of the case is, because of that mental illness, you're at risk of self-neglect or a danger to yourself and others, meaning that there's a substantial likelihood in the near future that you will create serious bodily harm to yourself or others. Okay, now what does all that fancy word mean? Well, as to mental illness, that is defined by the statute, and I love when a statute does that. Basically, the statute says that it's any emotional or mental impairment that impairs your ability to understand or comprehend reality. The definition diverges from the DSM-5 in some ways, in that unless there's a co-occurring mental illness, it does not include purely substance abuse, dementia, traumatic brain injury, or developmental disabilities. The DSM-5 covers things like autism as a mental illness. The statute does not. And it does, in a sense, make sense, because if you have dementia and there's no behavioral disturbances or developmental disabilities, you're not benefiting from psychotropic medications. And also, but we'll get into that more of that later. The compliance with voluntary treatment, this kind of just turns on the respondent's history. What have they done? Similarly with the lesser restrictive alternatives, that turns on really the doctor's opinion. The case law just says they have to be actually available, not hypothetical. So Karen just can't come into a case and say, he doesn't need to be hospitalized. He can just go live with his mother, who we've never talked to, or she's not even testifying in court. The case law says has to be actually available. The meat and potatoes, as I said, are the criteria. Self-neglect, or first night criteria, as we sometimes refer to it, and the dangerousness, which is second criteria. These aren't defined by the statute, but self-neglect generally means food, water, shelter, clothing, or a medical disease. Danger to self or others, you're looking at the totality of the circumstances for serious bodily harm. All right, so that's the criteria. What actually happens during the assessment? It's a 72-hour period. It's a strict deadline. You do not have a right to an attorney during the examination itself. During that, once the assessment is done, it has to be done in that 72-hour window. One of 3 things has to happen, unless, of course, the assessment ends on a holiday or a weekend. They're either discharged from the facility, and unless there's criminal charges, out the door. Second is they agree to voluntary treatment, or third, the hospital files the petition for treatment. This is actually, most cases get discharged at the 72 hours. And as a result, most people think, oh, you're Baker Act, did you go into the hospital for 72 hours? No, it actually isn't unless you file the hospital files the petition and I commit you, that's when you truly have been Baker Acted. And again, this is where Karen, Lourdes, and I become friends. What does a placement petition mean? It's a form that DCF creates. It's signed by 2 assessing physicians, one of whom has to testify at the hearing. It gets heard within 5 days, unless the patient exercises their up to 30-day statutory continuance. Even though the hospital files, the state attorney comes in as the real party of interest to move the case forward. The public defender is appointed unless they have private counsel, and these are held in the county or facility where the respondent is located. In most counties, the magistrate, PD, and city attorney, they ride circuit to wherever the hospitals are. In Pinellas and Miami, we have a host hospital, because I have 17 receiving facilities, and there's no way I could get from Aventura up north to Homestead down south and have any sort of sanity left. So we have a host hospital. And the patient does have a right to an independent medical examination, and they have a right to be present unless they waive that right. Now, we go to hearing what is the end result. Well, you could be committed for up to 90 days at a local receiving facility or an outpatient treatment, or up to 6 months if a transfer evaluation is done. Okay, it's the same criteria as we discussed earlier, only now I need clear and convincing evidence. What does that mean? You got to be more specific, basically. You can't tell me that a person is aggressive, threatening, and hostile. There's a case right on point from the first DCA in 1995, Wade v. Northeast Florida State Hospital. If you just say that somebody's threatening, that's great. But I can't tell if you mean you're threatening to kill me or threatening to sue me. Both can cause some consternation, but only one of those two things is relevant. I'll let you decide which one of those two it is. The case law says I have no contempt powers or continuing jurisdiction. But anytime, even if you're committed, you have a right to file a writ of habeas corpus to challenge the legality of your hold, or if the hospital has violated one of your rights. In those issues, it gets a little complicated, like if it's a legality, the state's still involved. If it's a right issue, it's the hospital's job. But the biggest point is you cannot be Baker acted if you have a mental illness, aren't taking your meds, and standing alone, just your mental health is decompensating. That's insufficient. It's in case law since the beginning of the whole process. So at this point in time, I'm going to stop at this point. We still haven't got your feedback yet from the Florida Supreme Court. I'll find out where we are on that. But Karen, you're up, and I'm going to stop sharing my screen at this time. So.
Hello, everyone. What I thought I would do is remind you first and foremost that when you're representing somebody who has been brought to a Baker Act receiving facility and they're having a placement hearing, you're not acting in their stead. You're acting to represent their rights, to make sure that they're not being held in the hospital inappropriately. And so sometimes it's really hard because you feel like, if they could stay in the hospital, they'd have a better quality of life. They'd function at a higher level. Everything would be better and happier for them. But that's not what the Baker Act law says. You're just keeping them in the hospital until they're stabilized and no longer, for shorthand, a harm to themselves or others, either through physical aggression or neglect. So what do I do when I first get a patient? I go to the hospital and I review the chart, and you should have access to the whole medical chart, whether it is an electronic chart or a paper chart or a combination of both. And you have to slog through all of the doctor's notes. And I suggest that you really read the items that the social worker puts in there and the other notes that are in the file. And it's important because throughout a 24-hour period of day, you'll see patterns and behaviors of people. And that way it helps you judge how they're doing and what they're doing. If you're there at the hospital, you can also speak with the nursing staff. I often spoke to the social workers and discharge planners, finding out about the family, finding out where they're headed as far as discharge plans are concerned. You get some more insight as to what the person's mental health history is. I also find it very helpful to talk to the, I don't know if orderlies is the right word, but the folks that are on the unit that are kind of keeping everything going smoothly. Because again, they're seeing the people often much more than the doctor does. And so it's important to see and know what they're telling you. Then I meet with the patient. And that also gives you an idea. If you do all this preliminary work, you understand what you're doing going forward. And be cognizant of stuff, especially if you're working with your older population. Are they hard of hearing? If they're hard of hearing, do they normally wear a hearing aid? Has the facility given them their hearing aid? Has their family brought their hearing aid in? What can you do to give them a hearing, increase their ability to hear? I know that the facilities in Palm Beach County we have the little magic microphone speaker things that our patients wear during the hearing or on the unit if I need to talk to them and they can't hear. It's important. Imagine if you're old, you're disoriented a little bit, and how disconcerting it can be not to understand all that's going on. So be real sensitive to that aspect of things. Find out stuff like, do they normally have dentures? Do they have their dentures in? All of those things make people sound and look and behave a lot worse than they might otherwise behave. Glasses, do they have their glasses? Do they need reading glasses? Do they have their distance glasses? Those are just human kindness things, but it also affects how they present themselves to people and the court. And so one of the things that you want to look into is, is the person there because of dementia and the nursing home facility is trying to dump them? Are they there because they're having dementia and they are with their family and the family wants to take a vacation? And so they store the individual at the mental health hospital? Sounds terrible, but it happens more often than you might expect. Are the children trying to gain influence over the elderly person? I'll digress for a minute. I had a story that was unbelievable one time. I had a very nice elderly gentleman, a little bit confused, nothing too terrible, wondered exactly why he was there. While we were waiting for the hearing to come, I got a call from the hospital that some of his family members, some of his children were meeting him at the chain link fence in the recreation yard of the hospital. And they had slipped through the fence to him a power of attorney for him to sign and return back to them. Fortunately, he got caught. They didn't get to change anything. And I was able to get a court order banning the family from the hospital, as terrible as that is. But I mean, just weird things happen. I had another elderly lady who had a roommate, and my elderly client, it was her home. She paid the rent and the mortgage, the electricity. This other person was just living with her. And she would monkey with my client's medication periodically so that she would be hospitalized. And that way the roommate had the home to herself. You just have to, when you're dealing with this elderly population or any mental health population, really have your radar on, listen, think, reach out, get all the resources you can so that you can tell what's actually happening. I had another client who come every Passover for, Lord knows, I did Baker Acts for close to 30 years. And I swear to you, every Passover, this woman was hospitalized, and it was because her son was going away. And you had to see that pattern, and you had to prove those things when you went to these hearings. So anyway, you're talking to the client, you're trying to get a feel for how they're doing. Can they hear okay? Can they see you? Are they understanding what's going on? And then you want to make sure that their behavior is such that it really needs psychiatric medication. Just because they're demented, just because they're confused, just because there may be some minor sundowning or behavioral disturbances late in the afternoons doesn't mean that they should be medicated or over-medicated. And you have to be very careful of that. One of the other things that you want to make sure is that if they come from a facility like a nursing home, skilled nursing home, if they are on a Medicaid bed, the hospital only has to hold the bed for 8 days. And if they're not back there, they don't have to take them back. Nursing homes don't have to take the client back or the patient back if they can say that they're not able to keep them there safely, or that they're a threat or harm to their other patients or their staff. And what you begin to see if you do this regularly is patterns of some nursing homes are forever sending people into the mental health facilities, and other nursing homes seem to manage them much better. And it's just like anything else, you get good in bad places. You'll see sometimes with mental illness among the elderly and other people, they'll say, well, it's a sign of their mental illness, they're not eating. Well, you need to find out why they're not eating. It may be that they only want to eat food that comes in a sealed container. They want to see the nursing staff open the food, open the cans, open the juice box, things like that. If that's what fixes the problem, then these folks don't need to be medicated. So what you end up doing is just, you have to be an investigator and a bulldog and get to the very, very bottom of the problem. Something that's often difficult is that the elderly, especially in elderly patients, they have a lot of medication that they're on treating their other illnesses, and you need to have a sense of how those medications interact, make sure that the medication that they're on, that's for their medical illnesses, their physical illnesses, isn't causing some of the problems. And you say, well, how do you do that? Sometimes you have to ask the court to appoint an independent psychiatrist for you so that they can go through the medications. I sometimes would call pharmacists and ask them about the interaction of the medications. Talk to the psychiatrist that's the treating psychiatrist, ask them about those interactions. Another thing that you need to do when you are representing any patient, whether they're elderly or not, is make sure that they're on the medicine long enough for it to start working. You'll have many psychiatrists that come in and they say, well, I put them on medication X and there wasn't any change, so then I moved them to medication Y, and now they're on medication Z. And if you are cross-examining them, you might find out that it takes 3 weeks to titrate them up to a therapeutic dose. And you might have to say, look, you can't just keep switching this medication around. Give it a fair try. See what it is that they're doing. And those are the kinds of things that I look for when I go in to meet with a patient. One of the things that's very difficult for families to understand is they will say, okay, well, we're going to hire our own lawyer to represent the person. And they're not really asking to have the lawyer represent the patient. What they really want is to have their views, interests, and desires represented at the hearing. And so as the lawyer for the respondent or for the patient, you need to make sure that you're representing the patient and not the wishes of the family, because those are two very, very different things. And you just have to be aware of that. If you have a guardianship over the person, separate and apart, having anything to do with the Baker Act, you need to realize that every time that person comes into the mental health hospital, they are going to have to stay for the 72 hours to be evaluated. And if they're going to be involuntarily placed or stay there, you cannot sign them in. They have to have a hearing. And again, that makes a lot of sense, because if you're a good guardian and you care about the person, you're not going to warehouse them in a facility. But this is a safety check to make sure that they're not being warehoused or dumped there by their guardians. And so you're able to watch and see what's going on. Let me see what else I wanted to cover. The magistrate had just briefly touched on the discharge unless they're criminal from besides doing the Baker Act, I was with the public defender's office for 35 years. And so a lot of times we would have clients that appeared to meet the Baker Act criteria, but the problem was the jails are not involuntary treatment facilities. So if the patient didn't want to take the medication, they couldn't be forced to take it. So we would try and get the folks brought to the mental health facility. And one of the things, if you're doing that, I would suggest that you try and get a copy of the formulary from the sheriff's office, so that if the individual gets stabilized on meds and gets returned back to the mental health facility, that you don't have the hospital put them on drugs that are not going to be available in the jail, because all that does is just complicate things further. We used the outpatient treatment orders, I think, very successfully in Palm Beach County. I was really proud of the work that we did with that, because sometimes you have people, they just keep going off their medicine and they get into trouble and they meet the criteria, and they get into trouble and they meet the criteria. And for a lot of mental illnesses, you never return back to your same level of functioning. And so you want to try and keep them as stabilized as possible. And they do have to meet the statutory criteria, and the magistrate's right. There is a lot that they have to do. They have to have been hospitalized twice within the preceding 36 months. They have to exhibit it either violent behavior to themselves or others, or attempt self-harm or to themselves or to others. And the state has to show that it is likely that they are not going to be med compliant and be successful without the outpatient treatment order. In Palm Beach County, when we had people on involuntary treatment orders, we had the community mental health assigned a case manager to those people. And so in the treatment plan that was part of the outpatient treatment order, they had to keep in touch with the case manager. They had to take their medicines. They had to keep their appointments. It might be that they had to live in a particular place or not change where they lived without the case manager's permission. We tried to not be restrictive, but to put together the things that would keep the folks in the community and have them be successful. One of my great success stories is I had a woman who she was elderly, but not as old as her parents, but her parents were her guardians. And she was always getting hospitalized. And the hospital had petitioned for her to go to the state hospital. And I had asked for an independent medical exam. And it turned out that the doctor that did the independent medical exam for me also happened to have been the doctor that did the evaluation of her and the family when the family got the original guardianship. And she said to me, your client's got mental health issues, there's no doubt, but her parents, who were in their 80s, were causing the problems. And so we were able to use the involuntary outpatient treatment order, and through that, the guardianship stayed in place, but we were able to appoint a guardian advocate as a part of the outpatient treatment order. That person they were not allowed to change the medicine unless the guardian advocate approved the change in medication. The woman remained outside the hospital, and after about 5 years of repeated outpatient treatment orders, she actually got her rights restored in the guardianship court, which was a really exciting, thing for us. So always try and think out of the box, use what tools we have. They're very, very limited. And just really know that it's important that for these kinds of cases that you are advocating for the person and what they would want if they were able to make the decision. And that's important for the guardian advocates to know, is that they're not making the decision as to what they would choose. They're making the decision as to what the individual would choose if they had the ability to do that. And it occurred to me, I don't think we've talked about guardian advocates yet so far, have we?
No.
Okay, so what a guardian advocate is it's generally either the person's guardian or a loved one or a family member who comes forward and volunteers to make the mental health medication decisions if the court finds that the individual is not cognizant enough to be able to make those decisions on their own. But if there's no family member around, or the family member is part of the problem, or you suspect the family member might be part of the problem, you can ask for a court-appointed guardian advocate. And that would be an individual who volunteers. They've been trained on their duties. In Palm Beach County, we have a little video, we have a little booklet for them to read, and they then become appointed, and their role ends when the person leaves the four walls of the hospital, unless there's an involuntary outpatient treatment order. So they're making the mental health decisions for the client while they're in the hospital. However, you can ask the court to allow them to make medical decisions also, if that's appropriate. And so keep that in mind if you're representing someone and they've got a lot of medical issues. That way, that person can go ahead and make those decisions for them when they're not competent to make them. Other strange things that we had, I had a client who was on dialysis, and dialysis was causing him to not be able to keep the therapeutic levels of his psychiatric medication at the levels they needed to be, because every time he went on dialysis, it washed the medicine out of him. And so we actually were able to find a doctor who took it on. And what they did was, instead of giving him his full dose in the morning, they gave him a quarter dose, and then a little bit more in the middle of the day, a little bit more later on, so that he always had something in his system, regardless of when he went to dialysis. And those kinds of changes happened to keep him out of the hospital, not all the time, but it slowed down the number of times that he kept having to return. So really, really think, when you're representing these people, how can you help keep them out of the hospital? How can you help keep them safe? But don't lose sight that your job is not to keep them there until they reach their very highest level of function. Your job is to keep them, to make sure that they're not there beyond their stabilization. I think that covers the most of what I have to say with regard to the geriatric people. And all I can just say is treat them with respect, because they're still people. Oh, I do have one other thing to say. When clients tell you things and it seems really, really bizarre, sometimes it isn't. Sometimes it really is true. I had an older gentleman, and he was telling us that he had been married to a princess. And we're thinking, don't think so. But he told us her name. We Googled him, looked him up, and he really had been married to a princess of some small country. I don't remember where it is. And so you hear things and you're thinking, can't be true, but sometimes it is. And so just be aware, be open-minded, care for these people, advocate for them, give them the dignity of having the hearing, because sometimes you are the only person that is their voice when they are in this hospital for doing nothing wrong at all. They're being locked up. They haven't broken any laws.
And I'll just jump in on 2 points that Karen mentioned. One is, is like something, it might sound bizarre. These individuals, they may be mentally ill, but they're not stupid. Catatonia does not mean that you can't understand what's going on. You just have to talk to the person differently. It's, you can never lose sight that these are, vulnerable adults that we're dealing with, and children. And one other point with the guardian advocate is a complication to wrinkle is sometimes, the downside of these hearings is it is adversarial in its inherent nature. And that's, it's great to protect the person's rights, but it doesn't necessarily always lead to the best outcome for the patient, especially in the sense that, and this is a point that I know Ms. Roberts was going to make, is some of the family, you might want to be involved, but if they're paranoid and you testify at the hearing, they might start thinking you're part of the conspiracy. So there's all sort of different considerations you have to weigh in when you're, the state attorney weighing the case, or also that all of us have in holding these cases. But I also have some news. The Supreme Court did get back to us finally, and they remanded all the cases. Doesn't necessarily mean you have to change your answer, but we all have to go back to hearing on these hearings. So you're going to get the same case. Wrong one. Stop it. Nope. There it is. Okay. You're all going to get the same cases, and you have to tell me again if you want to maintain the commitment or you can change your answers. It's entirely up to you. Now, come on. Okay. So on the last one, we had a majority said no. After hearing what Karen and I said, what is the verdict on this same fact pattern now?
And we are, I'm going to share it because I think the results are pretty overwhelming. Let's see.
All right, now we went to 92% no and 8% yes. All right. Karen, do you want to say what the problems that Lourdes, if she were here, if she presented this case, what the flaws were?
What the flaws in taking the
Yeah,
case
if I were to
is-
commit this person, where the flaws would be.
Okay, not taking your medication is not in and of itself a reason to have you be Baker acted. Again, that goes back to the idea of not the very highest level of function, but are you a harm to yourself or others? Delusional and responding to internal stimuli. There's a lot of people, you'd be surprised how many people in our society actually function every day, hearing voices that tell them all kinds of different things. But as long as the individual can learn to ignore the voices, or the voices are not telling them to do things that are harmful, then again, not a reason to Baker act them. We talked about it when I was speaking about we'll only eat canned food. Again, that may be your preference, and as long as you're getting the nourishment that you need, you're not becoming dehydrated or malnourished, not a problem. Slap the nurse in the face while being put in seclusion, not such a big deal as long as it's an isolated incident. Sure, it's not nice for the nurse. It could be as a result of some confusion, some sundowning, cranky, or the like.
Correct. And there's actually case law, 50 CA case from 2018. The person only was eating canned food. The state even conceded error, and the court said, yeah, without more, this isn't enough, because they're able to care for their basic needs: food, water, shelter, clothing. Now, if this were rotten food or dog food, that'd obviously be something different. And the slap in the face, it's a case Boiler v. State from the first ECA in 2000, that this is exactly all that happened. And the first ECA said isolated incident, not serious bodily harm. So the second case coming up, come on, there we go. Where is our audience now? Before we had a majority saying yes.
I thought I'd bring in some theatrics this time, so when the bell rings, all answers should be in.
All right.
The third one is going to have doing cartwheels?
I can reach over and get a bicorn and squeak that, if that would make everyone happy.
Perfect. All right. So now we still had a majority saying yes. If it's now 60% yet. No, sorry, 60% no. We had a switch from a majority saying yes. And this one would obviously, if this is the case, it's the case that would indicate you're correct. The first three are, again, just not taking your medication and having a declining mental health is not enough. The aggressive and threatening behavior, that's not specific enough. The state in this case, they would have to really press their witness to tell us what that means. So this, if that fact pattern came before me, the no's would probably have it without more facts. So now let's go.
Before you leave that, one of the other things is I've had where a particular family member or person was the trigger for the aggressive or threatening behavior. And so one might argue that as long as the triggering person stayed away, the client did not need to be hospitalized. And I've had the court rule in my favor and then speak to the triggering individual and get them to agree to not be around them so that it doesn't have these problems. So you want to make sure that it's pervasive if they're aggressive and threatening.
So let's go to the last case. Oh, come on. There we go. Would you still commit? The majority in the last case said yes. Would we still have a commitment?
The answers are trickling in.
Do, 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 do.
Oh, see that water going back up into the pipes?
Exactly. Hey, that's one way to save water. Just have me sing.
All right, I'm gonna call it unless there's a bell coming. All right.
All right, now we went from 68% yes to 75 and 25% no. Well, this case is a fact pattern almost verbatim from the third DCA. It's a case called Craig v. State in 2002. My predecessor actually was the presiding magistrate, and I can definitively tell you that under this fact pattern, no, you cannot commit, because while on Craig, the third DCA did affirm on other grounds, my predecessor found on this is emotional harm, and the statute used to allow bodily and emotional harm. It was amended in 1982 to restrict it to be serious bodily harm. So the third DCA said that if you have a case of stalking and harassment, you are not a candidate for civil commitment unless there's a threat of bodily harm. And the third DCA then spent about another 2 or 3 paragraphs of their opinion saying, "Dear legislature, please fix this," because it is quite shocking. And also it means the only remedy for the state in these situations is to arrest the person on the criminal charge and put him in jail. Jail does not help anybody in struggling with mental illness. The legislature has not, however, adopted this suggestion. There is some legislative efforts to change that, but so far, nothing. But yes, this is a case that would be a definitive no. Now, all right, so where are we? Now I have one.
Can I add one more thing? We were talking about with regard to law enforcement, if you're in a position of having to call law enforcement and ask them for help in getting somebody who is having some sort of mental health problem that's putting them at risk, tell the dispatcher that you are calling on a mental health case, because many of the jurisdictions have police officers who are specially trained to handle those individuals, and they have ways of de-escalating the situation, understanding the person's behavior. Often the community health mobile treatment units will meet the police out there so that you're getting the person safe help and you don't end up with the person committing suicide by police,
Exacerbating it.
things like that. And so use those resources. They are scarce, but they are there and they make a big difference.
The training program being referred to is a place called a crisis intervention training. And if you request a CIT trained officer, they will send somebody out. Most, especially in Miami, Judge Steve Leifman has really pushed this, and all our officers are trained down here. Mobile crisis units, there's usually only like 1 or 2 in a county, so it can be quite scarce. But again, that's at least just the crisis intervention training is you want that officer on the scene because they can talk down the person and either get them to calm down and avoid the hospitalization, or at least just make sure the person isn't death by cop, isn't shot. So let's go. I have one more poll question, one more case before you all, sort of, is now you're all, your patient, you are the plenary guardian for your ward, and he or she is in the hospital. You're the plenary guardian. The doctor's saying, we're ready to discharge to an assisted living facility. You as the guardian are saying, no, 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 we've done this before. They elope, it doesn't work. I want him to stay in the hospital. Who wins? The doctor, AKA people that are not smart enough to get into law school, or the noble plenary guardian that was appointed by the wise court and has the right to determine residence. See, who wins? The doctor or the plenary guardian?
Ooh, and this one's it's very neck and neck. Things are changing. Things are one way, the other. I'd give it a second because we're really close.
Like the Kentucky Derby.
Yeah, no, this is very exciting. I don't know if you can't see
They're
it.
coming up on the rail. They're coming, who's hugging the rail?
Oh, I can't share it
It's
now.
the,
You want me to share it?
we'll give it 5 more seconds. Get them in, get them in.
All right. Oh, good. We got someone to break it. I'm going to share it.
Okay.
It
You don't vote
was
no.
it was 50-50 until one more person came in.
So that one person tipped the scales in favor of the doctor. And I hate to say it, but the doctors, this is one of the, it's like a broken clock. They're right twice a day. The doctor's actually right on this one, much to the chagrin of every lawyer in this room. I know how that makes you feel. But there's a case from the first DCAs from 1994, Hanley v. Dennis, right here. You as the guardian can't keep them in the hospital. And the first DCA made a lengthy opinion, but basically it came down to there's an appropriate lesser restrictive alternative. The guardian might be 100% right. They're going to leave that ALF in 5 minutes because there's many of these facilities that aren't locked facilities. There is, as Karen was sort of talking about earlier, these lesser restrictives are the wild, wild west. There is no administrative oversight of any of these individuals. I actually had an ILF facility. It was a 2-bedroom house, and they said they were able to hold 7 people there. So again, this is a problem with the system and the discharge care. But yes, the guardian would lose this fight. So
I think it's really important as the lawyer for the patient. As I said, when I very first go in, I start talking to the discharge planners. And so one of the things that you want to do is to help identify what the issues are and what the problems are with the discharges in the past and have them work towards those, finding a solution, a different place, a same place, and working towards putting things into place that might be helpful. Again, not always successful, but I think that you can head off some problems with early planning. Don't wait until the person is stabilized to become involved in the discharge.
yeah, and that being involved and not waiting till they're stabilized is another problem with the system. You know, you have, as I'm going to talk about it with some of my final thoughts, we'll get to that in just a minute. But some final thoughts I have is, you know, as I mentioned, oh, come on, switch over. As I mentioned earlier, the numbers are increasing. You had 3 guardianship Baker Act cases to deal with this morning. I have about over 100 every week. From 2001 to 2019, and yes, I deliberately I stopped the number count after the pandemic because there was some weird fluctuations in the pandemic. There was 115% increase in the number of involuntary examinations statewide over that period of 20 years. There needs to be legislative reform, as I've mentioned, some areas that of concern. There are also issues, for instance, as I said, the state attorney comes in as the real party of interest, but essentially they're litigating these cases blindly because while Karen would have access to the medical records, the state doesn't. So the statute is basically taking the position is the state, you have the burden, but not the evidence. There's ways to get around that. But sometimes it takes additional time, and that 20 minutes these hearings are stressful for the patients. So that additional time can negatively impact the client, as that gets to the point I was saying, an adversarial hearing and the law side and the medical side can sometimes be in conflict. So there are legislative efforts to change some of these the statutes. We kind of also with the the multiple petitions that you have to file, one for inpatient, one for outpatient. We still have a very warehousing system model in place. There are more effective treatment models of like an outpatient, if it could be reformed in a way so that before you're discharged from the hospital, the hospital, without having to file another petition, can put you back on my calendar and then maybe order outpatient treatment and stabilize on, continue your medication compliance after you're stabilized. We could possibly help slow the revolving door, which is a common criticism of the Baker Act. Now, if you're a guardian and your ward is in the hospital, I encourage you to first bring the hospital a copy of your letters of guardianship. That way I know what authority you actually have. And I can avoid the guardian advocate appointment if you have the letters of showing me that you have the power to determine medications. I've had, in Miami, I have most of my jurisdiction in the county in my court system. I've had cases from Broward. I have no idea who they are. I've had, guardianships from Indiana or the Virgin Islands. They're not ratified, here in Florida. So technically you don't have the authority. So that's why it's nice to, it can avoid a guard advocate appointment. And if you, in patient consistency, it's important to have, one person and not disrupt that relationship with the patient as much as possible. Give the hospital a list of the medications the ward is on, because that's more information the doctors have. Let's say they're on 10 milligrams of lithium for the bipolar disorder, and it's not working anymore. The doctor might know, okay, we need to go to 20 or whatever. It helps them adjust the medications importantly, because you don't want your ward to be doing, their medication compliance to look like a heart rate monitor, because the more you do that, just up and down, up and down, up and down, they're on off. The science shows you're giving them dementia over the long haul. And that is kind of one of the problems of the state of psychosis, as Karen mentioned. They don't always come back up as high as they were, because the longer they're in that state of psychosis, the more permanent changes you're making to the gray matter of the brain. So it's, again, the science has come a long way since the Baker Act was initiated 50 years ago. And a lot of the science doesn't sort of comply with what the law you can do under the law. As I mentioned earlier, some of the issues about developmental disabilities, dementia, and traumatic brain injury. The discharge administrative oversight is a mess. DCF regulates Baker and Marchman Acts. Developmental disabilities are with the Agency for Persons with Disabilities. Dementia and traumatic brain injury are with Department of Elder Affairs. And as Karen talked about, we have a lot of cases where the person with dementia is just dumped at the hospital. And then the hospital, of course, are going to take the person in. And then the court's in this awkward position of, it's purely dementia. There's no planning in place. I can discharge this person to the street, and we know he or she's very vulnerable, and usually these people have no funding either, or you commit them because they might have some behavioral disturbances, but then they're in a locked hospital unit with truly psychotic patients around them all the time. That's traumatic for them. There's no windows in those facilities most of the time. And so they get further disoriented because they can't really tell, they lose track of time. So you need to know really what agency you need to work with and what you're trying to address. And then the final point I can't emphasize enough is take care of yourselves. You're no good to me or anybody sick. And as much as you're trying to take care, and whether it's a lawyer or to your guardian, whatever it is, your health is still, a number one priority. There are many, many organizations that have mental health and wellness resources. I just pointed to the link to the website to the Florida Bar, but I encourage you to take some time to take care of yourselves. For me, I go to the gym. That's my stress relief. Everybody should make time for that. So with that, I'm done. And so now we'll open up the floor to any questions, comments, concerns, or compliments. Karen, I like that one the most. Keep those coming.
Before we do that, I just, something that we didn't touch on, and I think it's a kind of good to dispel the old myths on it, but there's special petitions that can be filed for ECT, which is the shock treatment for folks. And that is very scary to lay people. But the science on it has changed hugely over whatever that movie was a long time ago. And I have actually gotten to be in the ECT suites to watch it happen. And they're put under a light anesthesia. The psychiatrist is there. There's a special hearing. The magistrate has to be able to order it. And the person doesn't necessarily have to stay hospitalized for the whole treatment regimen. They usually like to have the individual in the hospital for the first 10 to 12 treatments, usually 3 times a week. And then people get out and they can be on maintenance treatment. It helps tremendously with real severe depression.
Catatonia. It's amazing what that does.
And it is, you do sometimes have a little bit of short-term memory problems, but overall, please do not be afraid of this as a treatment modality in the right circumstances. It is an absolute miracle.
You know, I had one case recently. She came back in the hospital very depressed recently, but she got her the electric shock therapy 37 years ago for severe depression. She was fine. Relapse is often part of the recovery process or just part of the process. But yes, there are certain things that the guardian advocate, much like a guardian, you have to petition the court for extraordinary authority. ECT is one of them. Or really anything generally invasive would be a good rule of thumb to say that it's not ordinary, it's invasive. You might have to put somebody under anesthesia. Those are things you have to come back to the court for additional authority. So if there, with that, I think we'll open up to additional questions. Compliments most importantly, though, those keep them coming. Don't, even after we're done, keep them coming in.
So we'll start with that, and I'll take the liberty to go first. Thank you both so much. I've been sitting through, many of the sessions that we've had, and they've all been fantastic. But the interaction that you provided and the real practical knowledge that you both gave us, I think, is unparalleled. So I think this was absolutely wonderful. One of my favorites of the conference so far.
You can go ahead and say it was your favorite.
Yeah.
There's no bias whatsoever. Just it's there.
And so in the comments, you did get a compliment as well. That says, thank you.
Got one. We got one.
Got one. Thank you for the comprehensive information. I look forward to implementing some of your tips. So, and I can say to folks who are maybe a little shy to put stuff in the chat, on the virtual platform, I'm pointing over here because I have 3 different screens open. You all are here. You all are here. On the virtual platform, if you scroll down, there will be an option to complete a survey and leave comments. Your feedback is incredibly important to us. That's always how we make sure that you get the best conferences that you can. And so I don't see anything else in the chat or the Q&A.
I have one interrupt again. I'm good at interrupting.
That's okay.
Overruled.
That doesn't stop me.
I know.
But I wanted to let you all know that somewhere in your virtual world there is a handout that I had put together about the layperson's guide to the Baker Act.
Yes.
And it's a nice little, I think it's a nice little review and kind of points you in the right direction, points you the right part of the statutes, or something that you can give your clients or your guardian advocates or your guardians to kind of just answer real commonplace questions. So I just wanted you to know it was available.
Yes, thank you for bringing that up. For folks, again, underneath where the video is in the virtual platform, you scroll down, it says speakers, it lets you leave the feedback, description. There's a blue banner that says files, and there you have a copy of the PowerPoint, and you also have a copy of the pamphlet that Karen was just mentioning. So with that, we have about 4 minutes left. I don't see any folks mentioning anything right now, but I will reiterate the thanks and, speak for everyone when I say that this was really just a lively and really, really eye-opening subject. And you both presented just fantastically. So I don't know if I know you're probably tired of talking. I don't know if there are any closing things that you want to give us before we sign off. But if so, I turn it to you. Let me know.
Karen, you have any final thoughts?
I just want to thank you all for showing the interest, because This is an area of the law that's full of rumors, witchcraft, and ignorance, and anything that you can do to enlighten yourself, enlighten those around you, I think is really, really important. So thank you.
And I also want to say thank you for having us, but I also want to emphasize something. You know, the Baker Act, when it came in, it still is haunted by the myths of how the institutions were, 50 years ago. But we've come such a long way with the medications that are out there. So when we were doing these hearings, Karen and Lourdes and I, we are all sort of amateur psychiatrists in a way, because there's so much knowledge out there now. Like these things you have with the long-acting injections, rather than having to take a pill every day, where you can just get a monthly shot. You've seen people who've been homeless on the street for decades, turning around once they get the right medications. And Judge Leifman, who is here in the Miami circuit with me, he's had a jail diversion program where he basically for a year gets people on medications, and there's a lot more to it. There's trauma, wraparound services, and we've seen recidivism in our jail population in Miami drop by about 30%, and we've been able to save. We were able to close one of our jails in 2006 to save the county $12 million a year, because our jail system has become, ever since they closed the institutions, our default mental health care system. And the biggest flaw is, it's a huge flaw in the system that we don't have the same discharge post continuum of care for these individuals. It's a real shame. But the resources, sadly, the state doesn't provide it. We are about last in the state with in the nation, with only pending about $37 per capita on mental health treatments. But the results that you do see of some of these people who finally get it, the turnarounds are amazing to see. It really is rewarding. So, and it's amazing when you see them come in from the hearing, when they first come off the street to, if they come up on a second hearing for whatever, it's not the same person. And the medications, they have side effects, but if you get the right ones, it's really rewarding to see how these people could have normal lives again.
And another resource that we neglected to talk about was NAMI, the National Alliance of the Mentally Ill. They're a very good organization, educationally, support for family, friends, etc.
Well, fantastic. Thank you both for leading with compassion. It's very obvious that you do. Another compliment right at the end that came in. Let's see. This is really informative. However, the difference between healthcare proxy during crisis stay and the guardian advocacy as an alternative support mechanism for caregivers to developmentally disabled adults over 18 years old should be mentioned. Thoughts?
Well,
The difference between a healthcare proxy during crisis stay and guardian advocacy as alternative support mechanism.
Well, a guardianship advocacy is for persons with developmental disabilities, so that doesn't really come into effect into a Baker Act, because if, as I said, under the statute, if it's pure developmental disability, there shouldn't be in a Baker Act. There's actually another system for that's called 393.11. That is, if it's intellectual disability or autism, there are various developmental disabilities out there like cerebral palsy. Cerebral palsy, however, is more of a physical, not necessarily intellectual disability. There's a process in place for the state to put you in a group home for intellectual disability or autism. However, that is even a more procedurally dysfunctional statute than my issues with the Baker and Marchman Act, but that's a separate topic altogether. Alternative support mechanisms, the healthcare proxies. Yes, when you come into the hospital in a crisis, the hospital will often have somebody sign as a proxy for the person, but that proxy ends once if I declare you incompetent to consent to medication management. You have to have the guardian advocate. That's just what the statute says, and it's difficult in a Baker Act setting with all the advanced directives that are existed in a guardianship setting, because I have the hearing in 5 days. I don't have the luxury of necessarily litigating the validity of an advanced directive. like you would in a guardianship setting. And also, there's different trade-offs that you have to think, because as I mentioned earlier, this is actually a story that Judge Leifman tells. He was early in his judicial career. He had a person who was a former, went to Harvard, a very successful psychiatrist, had his first psychotic break in his late 20s. And, he was saying, all right, I'm going to get you some help. He listened to what the parents were saying and going on. And immediately he lost that person, because the person then thought Judge Leifman was part of the conspiracy that his parents were involved in. So, and I know Ms. Roberts would emphasize this point. So sometimes she deliberately does not call a family member into a case because she doesn't want to further isolate the person from their care group, because then they're more isolated, and it furthers the cycle of isolation and the spiral into crisis. So, the family has to weigh those options when you're in here. Karen, is there anything you want to add on that?
Well, it triggered something. I don't know if it's directly related or not,
Yeah.
but don't assume that because a person is involuntarily committed to a mental health hospital, that they're unable to consent to treatment. There are very many mentally ill people who have dealt with the illness for a very long time. They're very knowledgeable on the medication. They're very knowledgeable on how it works, whether they like the side effects, whether they don't like the side effects, what alternatives are good for them. They just might not have the insight at the moment that they need to be hospitalized. So don't think that those two things, the involuntary placement and the guardian advocacy, go hand in hand. They do not. They're very separate.
And there's many people who go in there voluntarily for treatment. And that's also encouraged in the statute. Sometimes when most of the cases get kicked out before during the examination period, another batch goes out during the 5 days waiting for a hearing, and because some of them they sign voluntary. So there's a lot of nuance here that we didn't get time to go into. So if there's any other final questions, comments, or concerns, if not, you can go on to your next meeting.
Awesome. Well, thank you again. Thank you for leading with compassion, for all of the information and being here with us today.